Good afternoon, everyone. Thank you for joining us for our CLE on how to do service and attorney ad litems for publication cases. My name is Kristen Solis. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program. For those of you that are not familiar with DVAP, as we affectionately call ourselves, we are a joint project of Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private pro bono attorneys who will work with their case from start to finish. We do all sorts of civil legal cases. We do not do criminal. We do not do personal injury or types of cases where an attorney can earn a fee. But the vast majority of our cases seem to be within the realm of the family law region. And with all types of the cases we need to know how to serve our respondents, especially in family law cases. Also, as sometimes comes up in family law cases, every once in a while we can't find the respondent. So service is done by posting or publication, and an attorney ad litem is needed to represent the absentee party. We are actively looking for attorneys willing to volunteer to be a pro bono attorney ad litem on our cases. So if you're interested in that, please give me a call, shoot me an email, and I'll add you to our list of folks that are willing to take those types of cases pro bono. We are blessed today to have two wonderful family law practitioners with us. We have Dawn Fowler. She is a solo practitioner and is board certified in family law since 1995. She has just concluded her service on their commission, writing and grading those board certification tests that she hopes never to take again. She received her JD from SMU. She is a former chair of the Dallas Bar Family Law section, and she also serves on the DBA Publications Committee and the Unauthorized Practice of Law Committee. She has received the Ken Fuller Pro Bono Service Award and the Chris Reed Brown Scholarship for her pro bono work. Jim Cobb is a graduate of Baylor University, got both his BA and JD there. He is a solo practitioner and has represented hundreds of children and parents in termination and divorce custody cases, and served as an ad litem in countless cases as well. He is also a member of the State Bar Family Law section and the Dallas Bar Family Law section as well. Both Jim and Dawn have been great mentors with DVAP, been CLE presenters and volunteers for many years with us, and have a wealth of knowledge. So as they do their presentation, if you have any questions, please put them in the Q&A section below, and they will try to get to them at the end of the presentation. So without further ado, I will turn it over to Dawn.
Thank you, Kristen. Thank you, everybody, for being here. Good afternoon. It's always nice to speak to people that I consider kindred spirits. So thank you for being here. Thank you for your volunteer service. If you're new to DVAP, I think you're going to find out that you routinely get back more than you give. You're going to learn things. You're going to learn things that are going to help you with your paying clients and your careers. I've gained so many good contacts and referrals and learned so much as a result of my pro bono service. And I've made good friends like my co-presenter, Jim Cobb. So it's a win-win all around. Today, Jim and I are going to be talking about service and publication ad litems. I'm going to talk about service first. Jim's going to pipe in with his experiences, and then Jim will present on publication ad litems, which he is the true Dallas expert on. Not just from me, but our judges agree with that statement. And then I will pipe in if he asks me to. These aren't necessarily exciting topics. They sometimes can be when you're trying to find somebody, but they are absolutely essential and critical. You can have the best pleadings in the world. You can have think you have the best court order, but if you don't have valid service, you have nothing really but a void order, and that does you no good, it does your client no good. So valid service, as we all know from law school, goes to the very heart of due process and personal jurisdiction. Um, and unfortunately, it's not hard to find cases where things were not done properly. I ask our local Dallas County judges for their input, and thank you for giving me your comments on this subject. And their most common response was the wrong name on the officer's return or the wrong date. So very simple things that are easily corrected, but fall through the cracks sometimes. There's been a whole lot of changes in how we do things, but the one consistent, constant change through my long career at this point is that there is a lack of consistency and a lack of conformity between our courts and what they require. So it's a little bit of trial and error. It's a little bit of having patience and perseverance, but you're going to have to check with your courts to make sure that you are doing things the way they want you to do them. Jim and I each prepared a paper that you will receive after this presentation. Jim's is very practical information on publication ad litems. I tried to be practical and give you a step-by-step guide to the various types of notification service to a respondent. So hopefully you can take those papers and use them, and just particularly the one on service, just pull out the part you need, read it, and you should be in good shape. But again, a disclaimer, nothing takes the place of reading the Texas Rules of Civil Procedure, the Texas Family Code, and other statutes that may come into play. You also need to check the Dallas County local rules. And then there's another Dallas County local family law rules. So there's two set of local rules that apply. And again, the website for the court that you are assigned to for their policies and procedures, and reach out to the court coordinators. They are wonderful, they're accessible, and they will answer your questions. And just finally, a practice tip: if you're not familiar with Texas Law Help, it's a website designed to help people who are representing themselves, but I have found it really helpful when I'm looking for a form, even in the service area, the affidavits that are required before you can take a default. So look there, they'll give you some information, some instructions, and I found that to be really helpful. Jim, any comments before we get started?
No, it sounds good.
Okay, so let me try to share my screen. Okay, so again, why is service important? Just one really important word, and that's jurisdiction. I had a hearing earlier this week where, fortunately, I was the ad litem in a probate proceeding. Their rules are very different than family law, but same principle. Unfortunately, at the very beginning of the case, the judge said, "Counsel, for the application, I can't go forward today because I don't have jurisdiction over your case because service has not been complete." So you got to do it. You got to do it right. You got to make sure the returns are on file. Everything has to be step by step done, or the court simply doesn't have jurisdiction to go forward. Fortunately, in that one, it's just a reset. But when you find out later, it could be fatal, and you could end up with a judgment that is void. So initial questions you need to ask: will the respondent sign a waiver? If the respondent will sign a waiver, then you can just look at that check sheet and go on and not worry about all these other things. If not, and that's going to be probably at least 50% of the time, do you know where the respondent's located? Number 3, what is needed? Do you need citation, which is just notification that a lawsuit has been filed? Or do you need citation and notice, which is notification of a lawsuit and a demand for an appearance in court? Number 4, who can serve, what you need, and how can they do it? Other questions you need to answer is the respondent in the military. You would think that would be a fairly simple service process, but these bases have their own rules, their own system of doing it. On page 3 of the service paper, there's a website to find out if the person is in the military, and once you find out where they are stationed, try to contact the base, because again, they will tell you how they want it done. Number 2 is a respondent in jail. Again, my inclination is go, yippee, I can find them. It's not going to be hard.
Dawn, I'm
yes.
sorry to interrupt you. Just to let you know, your slides aren't changing.
Oh, okay. Well, I'm going to stop the share and restart it. Hopefully. Okay, can you all see one that says other questions?
No.
Mine says service. Still, it's the cover sheet.
Oh gosh, okay. Well, this is not good.
It might be easier if you can click on the side slides that you're on right there.
Okay. Is that working?
Yes, that works.
Okay, good deal. Okay, so let me go back. So jail, you think it's a happy day, but sometimes it's not, because every jail facility has processes and procedures. I recently served somebody in jail, and they only did it on Wednesdays. And they only did it on Wednesday afternoons. And they didn't do it if the jail was in lockdown, and they didn't do it if your inmate was in the infirmary. So it took me like a month to get the guy served, simply because of their internal rules. But if you contact the local sheriff of the county, they'll know what those rules are, and they can help you through that. On page 35 of the paper on service, there's some websites that are shown that will tell you how to locate somebody if you do believe they're in jail. So when you know where the respondent can be located, there are basically 5 methods to use. First, obtaining a waiver. Second, personal service in Dallas County by the constable's office. Out of state, out of county, personal service, private process server, and substituted service under Rule 106. Okay, so I'm going to talk about waivers first. I'm just going to hit the points that people miss. In particular here, for some reason, even after all these years, a lot of people get a waiver signed before the lawsuit has been filed. And then they just fill in the cause number after the document has been signed and they get it back. That's a void waiver. Occasionally I'll see one that's been verified by the petitioner's attorney. Can't do that either. It has to be somebody other than the attorney representing the petitioner. You also can't use an unsworn declaration. I got used to using those during the shutdown, and they're wonderful, but you can't use them with a waiver unless the respondent is incarcerated. And a digitalized signature is not permitted. Some practice tips on waivers. The waiver that I included in your paper is just a waiver of citation. In other words, that all it waives is being served. So when you use that, you're also going to have to notify the respondent if you can't reach an agreement, and there's going to have to be a trial. If you use a waiver that contains both service and notice, they just say, I don't care, you don't have to notify me anymore. Make sure you check with the court to assure that the respondent hasn't withdrawn that and filed an answer. And also remember that almost anything constitutes an answer. If they just write a letter to the court and say, I want to be heard on this, or I don't agree, whatever, that is going to take the place of that waiver, and you're going to need to give them notice under the rules of civil procedure of your final trial. Jim, do you have any comment on waivers?
When I was doing waivers, when I used to be on the petitioner side, I would put in there to waive the record and to allow the associate judge to hear the case, because I know that happens a lot nowadays. So I also put those paragraphs in there.
Okay, thank you. And if y'all need a form for that, please feel free to reach out to Jim or me, and we'll be glad to provide one. So personal service in Dallas County, that's done by the constable's office. Truly, my biggest tip to you is to check in with the constable, find out which constable is going to serve it. And there's in the very back of the paper, there's a list of the constable's office along with a website where you can find out which office it's going to. Check to see if they're going to file the officer's return or if they're going to send it to you. And extremely important, once that officer's return comes back, make sure it's completed correctly. So often they're not. Again, the AJs all cited not having the name correct. It has to mirror exactly what is on the petition and the citation. Jim, any comment on that?
No, I'm good.
Okay. Next, certified mail. I'm not even going to talk about it. Don't use it. It does not work. One, it has to be done by the clerk, and people tend to think they can do it themselves. And two, if you get the green card back, it has to be legibly signed. I don't think I've ever seen one legibly signed. So just take that off your list of possible things that you can do. The next one is out of county or out of state service. Again, find out who's going to serve it. Most of the time it's going to be the sheriff's office. Again, check the officer's return. If it's out of state, the officer's return has to be verified before a notary public by the officer who served it. I've seen some come back where the office of the sheriff signed it, somebody just in the office rather than the actual officer. That's not going to be any good. Personal service in another country, call somebody for help. These are a nightmare, and they're very technical, and it's expensive. And if there's any way that your client knows something about where to find the respondent, you need to try to do it a different way. First, private process server, probably not going to happen too much in DVAP cases, but there is a list of certified people on the Texas Supreme Court website. You do not need, if you are using one of those people, you don't need an affidavit or a specific order, but if you have a TRO or notice of hearing, there's a little paragraph that you have to include. So be sure you do that. If the person isn't on that special list, then they do have to sign an affidavit, and you do have to have an order authorizing them to serve. Again, I can't say this enough. Check the officer's return, make sure they have done it properly. Jim, any comments about all those other kinds of service?
Nope.
Okay, you're being too easy on me. Okay, so now we're gonna, the last type of service where the respondent is substituted service under Rule 106. Judge Miskell, now on the Court of Appeals, was in Collin County. She calls this alternate service or alternative service, but the rules refer to it as substitute. So that's the language I'm going to use. This is when you know where the person is, but they are hiding from you. So you need a motion, you need an affidavit, and you need a court order authorizing the service. And the one thing that, again, the associate judges hammered was there have to be sworn facts about where the respondent can probably be located, and sworn facts that service has been attempted at that location at various dates and times. It's not enough to just say, we went out there at 10 a.m. Monday, Tuesday, and Wednesday. That's not going to cut it, particularly if you know that the person has a, an 8 to 5 job. Also, you need to include something in the affidavit that ties the respondent to that location. If it's their homestead, it could be something from the Dallas County Appraisal's office. It could be something that verifies their driver's license is at that address, their car is registered there, a utility bill, something that shows that that is where they live or work. At the end of the PowerPoint, I have an example of a really good 106 affidavit that was provided by Judge Tenite, and hopefully we will have time to go through that. Okay. What this authorizes the person to do, whether it's the constable or sheriff or private process server, is to leave the citation with anybody older than 16 years of age at the location, and or to leave it in any other matter, including social media, email, or other electronic technology. There again will be some information on that in your paper. Electronic service is still pretty darn new. Most of the judges commented that they very seldom see an affidavit that is good enough for them to feel comfortable authorizing it. Another associate judge, I believe it was Judge Tenite, said, yeah, I'll let you do it, but I'm probably going to make you do something else too, like publication. And there's a civil court in Dallas that on their website lists a whole category of things you have to do if you use service by a social media outlet. I've requested it, I've been denied it, but as an ad litem, I've also used it to connect to people, find their website, find their email. One guy had a business website with no physical office, but I did manage to track him down, and he did sign an appearance with the court, and they ended up getting an agreed order. Another lady confirmed that she was living at the beach, my ideal location to live, but she would go to a FedEx office if I faxed her something to sign. So don't dismiss using social media. You may just not be able to get a court order authorizing it, because the courts are going to want to know that it is a recent account. They're going to want some information that makes them feel comfortable that the person is actually going to receive the citation, and it's more likely than not that they would receive that notice as opposed to citation by publication. Jim, do you have any comments on that?
Yeah, on the social media, I've been appointed on those before, and I know under Rule 106, it's not normal for an ad litem to be appointed when you do a service under 106, but some of the judges are granting the service by Facebook or email, but they're putting in the order that if after that service has been completed, if the respondent is in default, they want an ad litem appointed, and I've been getting appointed on those. And I know for sure 2 courts are doing that. Judge, of course, it's the AJs that appoint the ad litem, so they're the ones that look at that order. But I know Judge Beecham and Judge Turner have been appointed ad litems on when they were served by Facebook or email. And I think Rule 109A, the last paragraph of that rule says why they're doing that. So, because I didn't know why they were doing that, but I think under Rule 109A, they're appointing an ad litem because of the substituted service.
Okay,
but they're not doing it under if you tack it on the door. And if you tack it on the door, you just need to. And Judge Turner called me on this one time. He said, Jim, it says tack it on the door, but is that the front door? Is that the back door? Is that the garage door? So we had to make sure to identify which door it was.
Right. And on the officer's return, it better say he tacked it on the front door if that's what the order authorized. You just can't, the constable can't say I tacked it on the door. It has to mirror exactly what the order says. At least that's been my experience. So this has to be done by an authorized person. You can't do it, petitioner can't do it. And again, the officer's return must be very clean. So let's switch gears to what do you do when you don't know where the respondent is located? And this will be substituted service under Rule 109A that Jim just mentioned, publication or posting. So under 109A, again, you don't know where the person is. You do have to have a motion, affidavit, and order. And again, sworn facts being the underlined word here, showing diligence in trying to locate the respondent and that you believe the method you are seeking to use will actually reach the respondent. Same authorized persons must do, not the attorney, not the petitioner, and the return must mirror the service done. Just like publication, which we'll cover in a minute, there's going to be an attorney ad litem appointed unless there are no children or appreciable property. My experience, and Jim, I'll ask you in a minute, my experience has been if there's generally they're going to appoint even if there is no appreciable property, just to cover all the bases. Motion for a new trial time frame is extended for 2 years, and you have to have a statement of evidence presented to the court at the time of the prove-up. Jim, comments on that?
I think anytime you do a publication in the newspaper, the court's required to appoint an ad litem. So even if you mess up and do a no publication on no child, no appreciable property, they're going to appoint a publication attorney because you ran it in the newspaper.
Okay.
And didn't do a posting.
Gotcha. And again, so on publication, again, you don't know where the person is located. You do have to file an affidavit showing a diligent search that is signed by the party or an attorney, not a non-party. But you don't need a motion or an order. And I do see a lot of motions and orders out there. They're not needed. But what you do need to do is fill out a request for citation that's filed with the district clerk. They use that to actually prepare the notice that is going to be published. And there's an example of those in the paper. That citation is served through a newspaper called the Dallas Daily Commercial Record. And as of a few years ago, they added a requirement that it is also served on the OCA internet website. So there's going to be 2 returns that you get back. The OCA is going to generate one and they're going to file it. And you're probably not going to get it independently. I always have to go in the court register to see it or to see that they filed it. And then the return from the Daily Commercial Record must contain an image of the publication. They've gotten, I'd say, latter years, I haven't seen many that were not done properly, but very early in my career, I found more than I wanted to that were not generated properly. And it's bad because in a family law case, you're going to have to hoof it down to the courthouse. You're not going to be able to see them online. So you're going to have to go down to the courthouse and physically eyeball them to make sure that they were done right. Jim, comments on that?
No, you're right on that. It's frustrating that you can't see them online most of the time. So you have to either get them from the attorney for the petitioner, but most of the time they don't know what you're looking for, or you have to go to the courthouse and pay for a copy.
Okay. So posting, I'm just going to say it's essentially the same as publication. It's not the same amount of time or anything, but you can look at the paper. I don't see very many people do things by posting, and you can't use them when there are children involved. Jiminy, do you see posting very often?
No.
Yeah, okay. So all this brings you down to default judgment. Respondent does not appear. What do you do? Again, Check the officer's return. I know I sound like a broken record, but that is the number one thing that I hear from the court. Make sure that the officer's return has been on file for 10 full days. Otherwise, you will not be able to take a default judgment. And that's even if the answer date is filed and the 60-day waiting period is filed. You have to have those 10 full days. You have to file some documents. First is the certificate of last known address. There's an example of that in the paper, and there's also one at the Texas Law Help website. The military status affidavit, again, in the paper and on the website. If you've done substituted service under 109 or publication or posting, the attorney ad litem will be there, as Jim said. That's very, very seldom waived. The court may want a report for the ad litem, and the role of the ad litem may vary by court. Some courts want a lot of stuff, and others are inclined to just go with the report, and they may or may not want the ad litem to be at the prove up. My experience has been they want them there, but at least on one occasion, I filed a report and I wasn't even given notice of the prove up, and the judge went forward without me. So it does happen. Also, a statement of the evidence. Again, there's a form for that in the paper. Basically, that just mirrors the testimony and evidence that's going to be presented at the prove up. Jim, any comments on those items?
I always file publication reports, and I always try to appear for the testimony. But sometimes, like you said, we don't get notified of the prove up, and most of the judges, because they see that report on file, will go ahead and proceed with the prove up, which is nice, instead of resetting it.
Okay. So I am hoping, I guess Jim probably joins me in this, hoping your next service looks like this, particularly mine. Okay. So Jim, I am going to turn it over to you.
Okay. I'm just going to give you some, from my perspective, some of the concerns that are frustrations that I have with, from my side of the fence as a publication ad litem, and also what maybe I could help the petitioner's attorney do. But one of the main things that attorneys are dropping the ball on is that they're not requesting the publication on the OCA website, even though that's been in effect for over 2 years. And I think the problem was, from petitioner standpoint, I don't know exactly what forms y'all have to fill out to request publication, but I know there's that in-house form that Don was talking about that I guess the district clerk has, that you have to check the box for publication, and it asks you how many times do you want it to run, and what at the bottom it says, what do you want the publication to say? That form for a long time did not have the OCA website box on there. And so the OCA wasn't doing any publications in Dallas County, but they were doing them for other counties, because apparently the in-house form in the other counties, when you check publication, it automatically included OCA. So it's very important that the petitioner's attorney check the OCA box, also the publication box. They might not have known, Don, what the OCA meant, because that's something new. But as Don said, it's 2 publications now, one through the Office of Court Administration, that's OCA. They have control of this public website that all publications are sent to them. They run them on their website for 28 days. You get a 1-page form back that's in very little print that you can barely read, but it's filed with the court. So that's required, along with the publication through the Daily Commercial Record. So make sure you check that box. But the other problem is some petitioners' attorneys don't know actually how the publication works with the Daily Commercial Record, because what they do is, or my understanding of what happens is, when you request a publication, the citation is typed up by the district clerk's office. That citation is called a publication citation, and it looks identical to on front and back to a regular citation, except it says publication citation at the top. And it's sent over to the constable. Usually it's constable number 1. And he gets the citation and logs it into his little book. And then he sends the paperwork, the citation plus the petition, over to the Daily Commercial Record. And as soon as the Daily Commercial Record gets it, they publish it in their newspaper. Even though they haven't been paid any money, they publish it. But the date they publish it is not the date that the respondent was served. And a lot of petitioners' attorneys thinks that's the service date. That is not the service date. They hold that paperwork in their file until they get their money. So usually then they send the petitioner attorney a letter saying we're entitled, I think it's $135 now, I could be wrong. And once you pay that $135, they send the paperwork back to the constable who's holding the citation. So then he pulls the citation, looks at the publication, and then fills out the citation and the date he fills out the citation is the date of service. And then he signs it and sends it back to the district clerk's office. The district clerk's office then file marks it. And that's the date that it's actually filed with Dallas County. So before we can proceed on the publication, that citation has to be on file for 10 days. And we count the 10 days from the date it came back from the constable. Plus, you can't default the publication respondent for 20 days from the date of service. The date of service was the date the constable got the paperwork, not the date the Daily Commercial Record published it. So if the Daily Commercial Record sits on it for 6 months and then it's sent to the sheriff and he signs it and sends it in, you still have another 20 to 25 days before you can default it, even though the publication ran 6 months ago. So a lot of the private attorneys are thinking, we're ready to default. But the publication, all I want to stress is the publication date is not the service date. So, and technically an attorney ad litem cannot go forward and file any type of report with the court or an answer until the person's in default. So that means I have to figure out the day he was served from the constable, count 20 days, go to the first Monday, and then make sure that during that 20 days, the 10 days also ran, and then I can file an answer. Sometimes the attorneys schedule hearings and the 20 days hasn't run or the 10 days hasn't run, and they're asking me, Jim, where's your publication? I can't file a publication report or an answer because he's not in default yet. I have to file all that stuff after he's in default. So just keep that in mind. Also, a publication ad litem is not I'll call it a Rule 21 attorney. I'm not the respondent's attorney for all purposes. I'm only his attorney just to make sure that he was served properly, that the service was done right, that the publication was run, the OCA was run, and that the relief that they're requesting is the same relief that the petitioner is putting in their order. Sometimes I'll see orders that come, they'll send me the order to finalize, and I'll look at the petition to see if what they're asking for, and some of the stuff that they're putting in the decree is not what they asked for in the petition, and I can't agree to that because I have to assume he's only before the court on what the request in the petition is, not something that they forgot to ask in the petition and now they want to add to it. So if they want to, sometimes there was one case that it was just a conservatorship, but then when the decree came, it was a termination. And so I said, y'all didn't plead for termination. Well, we want to make a trial amendment, and the judge is not going to let you make a trial amendment for termination. They're going to make you file an amended motion petition and get new service. And they decided not to do that because, it's expensive to do a publication. So I have to be careful to what I look for in the decrees because it has to mirror what the request is, because otherwise I'm not doing my job for the respondent. I'm not there to defend him and put up a fight to say the wife shouldn't have custody or she shouldn't get a divorce. I'm just making sure everything was done legal. So, sometimes I'll get hooked into a publication, and most attorneys that are ad litem, publication ad litems, I think have a flat fee. I'm not for sure about that, but most of them have a flat fee. And which means all we have to do is, check the publication, do our report, do our searches, send out letters, file the report. But sometimes the attorney for the petitioner wants to have temporary hearings. Some of the judges don't understand why they want to have a temporary hearing if it's a publication. And I don't either a lot of times. The only time I understood why we had to have a temporary hearing if it was a publication is because the petitioner needed a passport right away for the children, and we weren't ready to finalize it yet, but the judge did grant a request for a temporary hearing, and the judge gave her temporary custody to get the passports. But there's been cases where they started off with they wanted a restraining order, and then they had to go back to court because they couldn't get service, and they had to extend it. They extended it again, and they switched it over to publication, and they still wanted to continue extending the TRO. And the judge and I were standing there looking at each other. If you don't know where this person is, why are you coming to court to extend this? So I had to charge them some extra money for that, which I didn't like doing. But I'm not the engineer of the train. That the petitioner's attorney is an engineer. I'm just kind of the conductor. But that's one of the problems that we have, is that we expect just a certain thing to happen on these publication ad litems, but a lot of times we have to go to temporary hearings. Another issue I'm having sometimes, or publication ad litems are having, is when we look at the affidavit, it doesn't give us a lot of information. I do have an assistant that contacts the respondent or the petitioner to get the information on the publication respondent. We ask for his date of birth, even though we may already know it, we still verify it, but we ask for his date of birth, when she last saw him, his country of citizenship, where he works, relatives. So that gives us an idea of, when we use our websites to try what we put in our websites to try to find the person. But if the affidavits really could be a little bit more specific, saying, his birth date is this, he grew up in this town, his last known email address is this, his last known phone number is this, the last time I saw him was this. And I see some like that, but that's up to the attorney though. All the family code requires is that the affidavits say, I don't know where he is, he's a transient person, I've exercised due diligence to locate him, and I can't find him. And that's what most of them say. So, we don't mind, as the publication attorney, contacting the petitioner and getting all this information, but a lot of times they don't understand why we have to know all this. So it would be helpful if the petitioner's attorney told them, we're going to be asking them a lot of questions, and there's also going to be a fee. Sometimes they don't understand the fee. They say, I've already paid my attorney your fee. And they really haven't, but they weren't expecting that. So there's sometimes a communication gap between the petitioner's attorney and their client as to what a publication ad litem does and why they have to charge money for it.
And Jim, how do you get paid? Who pays you?
The client, well, my procedure is when I get notified of the appointment, I ask the attorney to send me the documents I need and his client's email and phone number. And I explain to him that usually when we get the information from the respondent, when we call them, that we'll explain to them the fee, and that they can either give us their credit card information over the phone, or I use lawpay.com and send an email to that email address. And then they just pay that way. But I always explain to the client and the attorney that once we collect that information, we don't do any more work on the case. And right now I've got 14 cases sitting over here in my need payment file that we've contacted the respondent, we've got the information to do the search, but they just haven't paid. So what I do probably every 30 days is go through that file, notify the attorneys, hey, we've got the information we need. We sent the link to your client to pay on such and such a date, and they haven't paid. Sometimes the attorney responds, well, I'm not getting paid either, which is okay. But sometimes, all of a sudden money starts coming in because they weren't aware their client hadn't paid, and they called them up and said, hey, we've got a DWP date. You need to pay Mr. Cobb his fee so he can do his search. So that does help to notify the petitioner's attorney that we get paid.
Are you ever paid by the county?
Do what?
Are you ever paid by the county?
Only if I'm a CPS publication ad litem. Some of the pro se's think that I should be paid by the county, so I have to explain to them that the county is Dallas County citizens and they shouldn't have to pay my fee for helping you get your divorce or whatever, and they understand that. I do get a lot of pro se publication ad litems, and typically I add an extra $100 to that fee because they have no idea what they're doing and I have to spend more time with them. And sometimes the court expects me to kind of hold their hand through the system instead of them going in front of the judges for all the status hearings and stuff like that. So I kind of take over the case at that point. So I charge them a little bit more to do that. But the other thing that I was going to do was just cover some of the rules, because I know that one thing I do is I go to Bible study. So when I go to Bible study and my Bible study teacher says, this is what I believe about this, we say, well, can you show us that in the Bible? So I know a lot of times an attorney will stop me at the courthouse and say, Jim, where does it say we need a statement of evidence, or where does it say, you do or don't have to file a report with the court? So I went through the family code, I went through the civil procedure code, and came up with some of the rules that y'all really need to look at. If you do have, your family code or your rules of civil procedure, you're welcome to follow me. But one of the rules is in the civil procedure, Texas Rules of Civil Procedure, is Rule 107. That basically, that's one of the rules that says that the return has to be on file for 10 days. Some attorneys are not aware of that, but that's buried in that rule. I mean, that's just not the rule that says 10-day rule. It's buried in a lot of stuff, but it's 107H. There's Texas Rule of Civil Procedure 109 that talks about publication. And as Dawn said, you don't need a motion and an order to do a publication. I see those quite a bit. I'm thinking, why are attorneys spending their clients' money for a motion and order to do publication? Because all you have to do is take it to the courthouse and, say I want a publication. There's 109A we've already talked about. That's substituted service. And I said that under Rule 109A, it's the very last 6 or 7 lines where if a respondent is in default, they're going to appoint an ad litem, and that's what they're doing on social media service. Then Rule 110, Texas Rule of Civil Procedure 110 is important because basically Rule 110 says if there's a specific rule that applies to this case, then that specific rule trumps this general rule. So Rule 110 basically says the family code trumps the Texas Rules of Civil Procedure. To see if there's any conflict between the two, you always go with the family code. And one of the big things is that if you look at the family code says the publication only has to be run one time. The Texas Rules of Civil Procedure say it has to be run 4 times. So you only have to run it one time because it specifically says in the family code 1 time. But I've seen, unfortunately, attorneys not know that. And when they fill out that form, they put 4 times. And that means that's $135 4 times instead of $135 one time. And so their clients paying $500 and something bucks to Daily Commercial Record to run the publication when they didn't need to. Also, there's another difference is that citations by publication, just as a general rule, according to the Civil Procedure Code, you have to wait 42 days to default. Our rule is 20 days. So that's a different, there's two different rules there. So that's something that the attorneys need to keep in mind too. Then there's Rule 114 in the Texas Rules of Civil Procedure that talk about requisites for publication. But like I said, the Texas Family Code pretty well has their own rule on how that works. There's Rule 116 that talks about the public information website. That's the OCA website. It has to be maintained to the Office of Court Administration. One thing you need to know, it talks about doing the newspaper publication. A private process server cannot serve a publication. I had one case where the private process server turned the paperwork in, ran it over to the Daily Commercial Record. They called the process server when it was ready. He picked up the publication, filled out the citation, turned it into the court. Can't be done. The publication can only be served by a constable or a sheriff. So you got to keep that in mind. Rule 244 of the Texas Rules of Civil Procedure talks about an appointment of an attorney ad litem and talks about the need of needing a statement of the evidence. So I know a lot of attorneys say, I don't want to do a statement of evidence, but you have to do, anytime there's a publication, you have to do a statement of evidence. As the publication attorney, I do those. If I don't volunteer to do them, but I'll do them because if I know the attorney pretty well that needs one, I'll just do it, put it on my system and send it over to them when I sign off on the decree. I'll do that. Then there's Texas Rules of Civil Procedure 329, which says if you do a publication, the motion for new trial time is not 30 days, it's 2 years. And what you need to be aware of is if an ad litem is appointed under 9A and the courts right now, I think, are really considering that the service about social media as a publication, then that statute of limitations is probably going to be, or the motion for new trial time will be 2 years, not 30 days under that provision too. So you got to keep that in mind. The other rules that are in the family code that apply to publications are, well, there's this 6.409 is the main publication rule that says you only have to serve one time, not 4 times like the civil procedure says, and you can default 20 days, not 42 days. It also says, and I learned something every week, which is scary. But if you have no children and a property divorce, you can do a posting even if you have property of value, but an attorney ad litem has to be appointed. And I tried to figure out what was going on because some of the judges were appointing me on posting cases. I didn't think you needed an attorney ad litem on a posting case, but it always was because maybe somebody had bought a house before the marriage or there was retirement. And I was saying, Judge, do you want us to do a new publication? Nope, don't need to do a new publication. So that section that I just referred you to in the family code says if there's appreciable property, you can still do a posting as long as there's no children, but they have to appoint an ad litem, which also then you have to do a statement of the evidence too. So even if you do a posting, you have to do a statement of evidence. One thing you need to be aware of is that 82.043, the application for protective order, you can't do a publication on somebody you're trying to get a protective order against. As a general rule, if you file a motion for contempt, you can't do a publication on the respondent because he's not paying his child support because you don't have personal service. The 102.009 of the Texas Family Code says that if the 4D agency is involved somehow, and even if they're not officially involved, I think if the children are on some type of food stamp program, healthcare program, the Attorney General's office has to be notified of any suit that's been filed so they can intervene. And one thing y'all need to know is because a publication ad litem is not a 21A attorney and somebody intervenes in a case, they've tried to send me under Rule 21A a copy of the petition or their intervention. And it's not going to work because I'm not a 21A attorney. They're going to have to run their own publication on their own intervention or their own cross action if it's asking for relief other than what's already been asked under the first publication. So all I'm saying is you can't piggyback on somebody else's publication because they have their own relief. If you've got different relief, you have to do your own publication on your relief. I think 107.014 of the Texas Family Code describes rights and duties of a publication attorney. That, and I'm not saying that applies to all publication attorneys. That may just apply to publication attorneys that have been appointed as when a government entity is involved. But I think it applies to all attorneys ad litems because it tells you what your duties are to look for an unknown father, or how to search for these people. If you find them, what you're supposed to do. It says they want to see a publication report. So I try to follow that rule pretty well. One thing that, as a tip to save money, and you may know this or you may not know this, but if you've got an unknown father, that is a party, and his name is unknown, and you need to do a publication on unknown. And if you've got two publication respondents, you can do it in one citation. You don't need a citation for an unknown. You don't need a separate citation for Billy Joe King. You can put unknown, Billy Joe King, Mary Ruth, have as many names as you want to on that one citation, and you run one publication on 3, 4, 7 names, and it's good. Family Code and the Rules of Civil Procedure allow you to do that, which saves y'all some money. Now, that might not save you any money with the publication ad litem because they've got to do all the searches for all the people, but it saves you money with the publication people because you just need one citation and one publication run. And I think that's all I have.
Okay, Jim, we had a couple of questions and we have about 3 minutes.
Okay.
So I don't know the answer to this one. Do you know if a person who is certified to be a remote notary can notarize and get on a digital, I can't say it, a digital signature? I don't think digital signatures are allowed on waivers, but maybe there's an exception for a remote notary.
I have no idea.
Okay, I don't either.
I don't know.
Okay. To the person that sent that, if you will give me a call, I will try to figure that one out. Can you comment briefly on use of foreign language newspapers or small town newspapers for publication?
Yes, I can do that. You do your publication in the county that the suit is pending. So if your suit is pending in Dallas County, you do your publication in Dallas County and you use the Daily Commercial Record. You don't use the Dallas Morning News, you use the Daily Commercial Record. If you think your respondent is down in Weslaco, Texas, you don't run a publication in Weslaco because you think he's down there. You run it in the county, and the Family Code or the Rules of Civil Procedure say you run it in the county that you filed your petition. And I don't know that there's a Spanish newspaper in town that will do that for you that meets the qualifications to run publications.
Okay. If you're in a small county, I know there's a rule on this, I just don't remember what it is as far as where you publish.
I guess if you're in a very small county and they don't have I think there is a rule that, well, I know there's a special rule that if the publication is, I think it says if the publication is over $200 or you don't have a newspaper in that county that does it, you can do the OCA alone.
Okay.
That's an exception, and that's an exception for a lot of nonprofits that if they filed on a affidavit of indigency, you don't have to do the Daily Commercial Record. You only have to do the OCA.
Okay, there's a follow-up to that. If another paper is more likely to be seen by the respondent, can you use that other paper? I think the answer is no. I mean, I think you have to apply to the court for a different type of service.
Yeah, I mean, if you want to use that paper, I would get an order authorizing that paper to be the run.
Okay, and I think you addressed this, but in a domestic violent case where the respondent is the perpetrator, should the ad litem contact the respondent? I guess that would be a 109, maybe.
Yeah, well, under that section about what ad litems are supposed to do, if the woman is a victim of violence and she's the one I can't find, but then I find her, I'm not required to furnish her address, okay, to the court. And I've had those circumstances. So what I tell the people that I do is I say, give me an address of a relative or a close friend that you know you can stay in contact with, and we'll do a pro se answer for you. Put that address and phone number and their email on the answer, as long as you stay in contact with them, you'll know what's going on in your case. So you don't have to give your address, but it better be a good address that if the court sends you some mail to, that you're going to get.
Okay. Jim, thank you so much. As usual, as you just said, I learn something every time we do this, and I learned at least 3 things from you this afternoon. So,
That's scary.
I know that hopefully I had just forgotten them, but no, I don't think I knew them. So